has been titled Resolving Legal Disputes. We're quite fortunate to be joined by Zahra Al Rikabi, who is a distinguished barrister at a leading set in London. I went through her CV this afternoon, and I could take you through it, and it's quite an illustrious CV, but I should say that she was called to the bar in 2012, having had her BA in jurisprudence from Oxford, and over the years has had glorious references from legal directories in the UK for her work that she's done both in the UK and internationally. But without further ado, I'll hand over to Zahra to take us through resolving legal disputes this evening.
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you for that kind introduction, Brother Karar. I am going to share my screen. Inshallah, this will work so that we get the slides for this presentation. So the title, Resolving Legal Disputes, is probably a little bit misleading because I've got a very particular way of resolving legal disputes in mind, and I'm not going to be covering the whole plethora of things that one could do to resolve a legal dispute. But when you think about legal disputes, you think about conflicts, and you think about conflicts with a legal dimension to them. And so the questions that normally come to mind is, okay, what does the law say about this, and who's right and who's wrong, and who wins and who loses? And ultimately, who gets to decide these things? In our minds, we imagine a jury declaring verdicts or a judge deciding the winner and the loser. In the context of legal conflicts, the winner normally takes all. The loser is left not only having not obtained anything, but also lumped with the other side's costs, as well as their own costs. So before I go into the question of resolving legal disputes, I wanted to stop at the word conflict and just explore that a little bit before we move on to the particular context of legal conflicts. So the first thought I wanted to share with you all, and I'm necessarily sharing at very high level, all of these thoughts could be unpacked in their own talk for many hours with really interesting discussions. The very first thought I wanted to address is our idea of what conflict is, and what immediately comes to mind when we hear the word conflict. And I wanted to position the question, well, is conflict necessarily bad? One really interesting book that I've come across through the years is a book by David Augsburger, I'm going to mess up his surname, called Caring Enough to Confront, which I thought was a very, very interesting concept. And I'd recommend that anyone interested in conflict resolution have a look at it if you are interested. But he shares the concept that conflict is neither neutral, that conflict is neutral, so it's neither good nor bad. And the goal of conflict, or the goal that one should pursue in a conflict situation, is to combine both I want relationship as well as I want honesty and integrity. So combining messages of I care and I want. And he sets this out in this matrix that I've included on the slide. And the idea really is that conflict arises whenever people disagree. And disagreement is almost inevitable between human beings because we all have different backgrounds and different needs, different perceptions, different wants. And in the context where there is a clash between what I want and what you want, and what I need and what you need, we have options. And these options could be either a high concern for relationship, which is where I put the relationship above my needs, or little concern for relationship, where I put my needs above the relationship. And then on the other end of his spectrum, there is little concern for goals. So this is where, the only thing I'm thinking about is the relationship, and I'm not thinking about my values and my needs and what I want to achieve. And then high concern for goals. And the idea that he puts across is that it's possible, indeed desirable, and should be our first port of call to try to combine high concern for relationship with a high concern for goals. So there is a way in which I can both care about you and confront you about what I need. Mediators beyond borders have one of their alternative definitions of conflict I decided to include on this slide, which is conflict as an opportunity and a request for authenticity, acknowledgement, intimacy, empathy, understanding, growth, or learning. In other words, a request for a better relationship. So this idea of conflict not only not necessarily being a bad thing, but actually being a request for a better relationship is a really interesting way to frame our starting point. So you may well be thinking at this point, well, if conflict is all these things you say, how come every time I'm involved in one, I'm left feeling angry, misunderstood, frustrated, and in lots of pain? And this is where we come to another concept I want to just touch on very briefly today. And again, this warrants, I mean, it is taught over, week-long retreats. So I'm not going to attempt to summarize it in one slide. But what I would suggest is that the reason we find conflict so painful is because we often lack the tools to engage in conflict in a constructive way. And one of the ways that one could actually learn, just simply go and get some training in, to transform conflict in their life is called nonviolent communication. You may well have heard of it. And it was coined by someone called Marshall Rosenberg, who's written various books about it. I've just included one quick passage here from a book called Living Nonviolent Communication. And the idea of nonviolent communication is a 4-step process, which you don't have to follow rigidly, but it's about understanding the concepts in that 4-step process. And the first step in the process is observation. So that, I think, for us as Muslims is normally about sort of self-knowledge, I think, and consciousness, and sort of not just being on autopilot. So if you just stop and observe what's going on, you can just describe what you observe without judgment. So that's the first step in his process. Then the second step in the process is to check in with yourself and think, well, how am I feeling about what I'm observing? The third step in the process is to own your needs. And that's where the courage comes in. And I say courage, I really do think it takes an enormous amount of courage to personalize what you need, and to say to somebody in a conflict situation. This could even be a business conflict situation. I'm not necessarily talking about family disputes here. In any situation with any person where you are feeling some clash between what you need from them and what they need from you, or what's happening in the situation, what do I need right now? And if you go on any of Marshall Rosenberg's resources, there's lots and lots of things online, you will find published lists of feelings and needs, because the reality is most of us are not even literate when it comes to our feelings and our needs. We expect people to meet our needs when we don't even know how to articulate them, and we don't even know what we're feeling. But yet we sort of expect people to clock on to how we're feeling, address how we're feeling, meet our needs without ever having communicated any of these things. And so we come to the final step, communicating those things, and that's the request. And in his teaching, the distinction between a request and a demand is whether you truly believe the other person's free to say no. If you don't think they're free to say no, then it's a demand. It's coercive, it's not a request. So anyway, this is touching very briefly on the concept of NVC, just as one potential tool that people could use in their day-to-day conflicts. So I started with conflict isn't necessarily bad, it's necessary for growth, it's necessary for good relationships, it's necessary for progress, it's necessary for innovation. And then how do we conflict well? Let's go out there, let's look at the tools that are out there, and let's try to have better conversations. Now, if we start from that background and move on to legal disputes, are legal disputes really an entirely different category of conflict? You know, are they completely removed? I mean, you might be thinking, hang on, you know, I'm thinking landlord and tenant, I'm thinking consumer dispute, I'm thinking breached contract. You know, why are you waffling on about nonviolent communication? And here I want to share an image with you that was shared in my CEDR mediation training, which I think really captures very well what's going on in a legal dispute and why legal disputes are not as far removed from the other things I was talking about as you might imagine. So at the top of the iceberg, and this is, you know, the cliched iceberg metaphor that we all know very well from a whole host of other contexts in life. But the visible part of the iceberg is the stated positions between the two parties to a legal dispute. And everything under the waterline are the actual interests. So what's the distinction between positions and interests? Positions are where the parties are essentially positioning themselves, what they are demanding of each other. And so that will be your claim form and what you demand and what you say is the right answer and what you say are your rights in this particular legal context. And it's normally information known to others because you share it with the other side. You put it in quite cross, you know, solicitor correspondence, and you, you know, get quite acrimonious about it. But those are all your stated positions in the context of a legal dispute. What is then unknown to others are all your interests in pursuing a particular legal dispute. And there you literally can have anything. You can have all the interpersonal issues that I was touching on earlier in the context of explaining what conflict is and talking about NVC. You have needs, you have concerns, you might have health issues. You might, and the health issues are relevant to the claim because actually pursuing this acrimonious legal claim is having an impact on your health, and you haven't told anybody that because that's not something you write in your legal correspondence, right? What you stick to is everything that shows at the top of the iceberg, but what's going on underneath the surface is a whole host of other issues and a whole host of other needs that arise in any conflict between two people, yes, but also, in fact, corporations. Even when a legal dispute arises between two polished corporations, you still have some of the things sitting underneath the surface, for example, like reputational risk, that are not going to be addressed with the other side. If we fear that if we lose this, or even if we don't lose this, if we put, you know, if you're being sued for negligence, for example, as a corporation, if they put your witnesses on the stand and they come across really badly and a damning judgment is written about your corporation, there's still a reputational element you have to think about. There are financial pressures for corporations. They may have other priorities, so they don't want their CEO and their COO embroiled in a legal dispute. They want them to be focusing on improving the business. And so these issues arise across the board in the context of legal disputes, and are certainly not limited to disputes where there is a heightened interpersonal element, but of course they arise even more in that context. Which brings me to mediation. I mean, some of you may be familiar with mediation, others might have no idea what I'm talking about. And I wanted to start with a quotation from a mediator, a very well-known mediator called Bill Marsh, because it really touched me, and I think it captures very well what mediators do. And what he says is that mediators are bearers of hope and agents of reality. And I think it's really important to have both of those ingredients in the role of a mediator. So why are mediators bearers of hope? It's because the mediation process is one in which people have to take a leap of faith that getting together and engaging in the process may lead to resolution. Nobody can guarantee that it will lead to resolution. It may well not lead to resolution, but it starts with that leap of faith that if I just simply engage in a process and I engage in it as well as I can and I engage in it fully, then perhaps this mediator bringing us together could be a bearer of hope for this situation. Equally important, mediators have to be agents of reality. And often our job is to reality test. That's the language we use. But when you're sitting in the privacy of the two meetings, and maybe I should start with sort of a really, if I should step back a little and just explain at very high level what might happen in a mediation. So the mediator would normally contact each party separately to have an initial chat with them about process, to explain the process to them. And then if the parties are agreeable, they would be brought together in a plenary session where they then talk about, they introduce the dispute, if you like, or they introduce what they're hoping to achieve, or they introduce what they're there for that day. And then the process is very fluid and organic beyond that point. So it's very much up to the discretion of the mediator in consultation with the parties to either split them up again into private rooms and to shift between the two of them. And the mediator's goal is to create a safe enough space. I say safe enough because you can't guarantee that it will be safe, but a safe enough space in which people are able, and those are the words of my colleague in Chambers, Stephen Russell QC, who says, our task is to create a safe enough space. So if you're able to create an environment of confidentiality, people are able to understand that anything shared with the mediator in a private meeting would never go across to the other side unless specifically authorized to do so. And mediators will often write down what you've allowed them to say so that they only ever say what you've allowed them to say. But when you create that feeling of sort of safe enough, people begin to disclose to you some of the things that I mentioned as being beneath the waterline. They begin to explore with you what their interests are, going beyond their stated positions. They may well tell you, by the way, this is destroying my health. This is destroying my finances. My wife said she's going to leave if I don't stop fighting about this with my business partner. All sorts of things come out that then begin to shape the dispute. And when the mediator has that knowledge, even if they're not allowed to share it with the other side, once somebody has that insight, and before the mediator came along, nobody had an insight about both parties, right? So each party was in their own camp with their own cheerleaders and their own advisors, and they only ever communicated with each other in the positions category of communication. But once they allow the mediator into their confidence, the mediator can reality test with them, can get creative with them, and can begin to explore ways of moving forward with them. So mediators are bearers of hope and agents of reality. Just a couple of things. I've described mediation in very high terms in terms of the process, but I wanted to point out 3 things that are normally included in the mediation statement. And in order to engage in a mediation, both parties have to sign, as well as the mediator, have to sign a mediation agreement. And the mediation agreement covers at least these 3 key things. Firstly, that the process is confidential. So it's confidential as a whole. Everything said during the process can't be repeated outside the process. But as I also mentioned, within the context of private meetings, everything said to the mediator is treated with the utmost confidence until the mediator is given permission to share some of it with the other side. Secondly, the process is entirely without prejudice. What does that mean in non-legal jargon? It means that even if you're having a legal dispute that is already commenced, so you've already issued proceedings, you're already in court, you've already exchanged angry lawyer letters, you might have filed your claim, you might even have started some procedural hearings. Anything admitted in the context of the mediation, conceded in the context of the mediation, shared in the context of the mediation, can't be brought to those legal proceedings. You're simply not allowed to show up in court and say, well, he admitted this when we were mediating yesterday, therefore you should find in my favour. So the signed mediation agreement is a legally binding document in which both parties have promised to keep everything that comes out in the mediation confidential and without prejudice to the legal process. And finally, nothing is binding until an agreement is documented and signed. And here's where I think mediation is potentially really, really transformative. See, as a barrister, as a lawyer, as a litigator, I quite like telling people what to do. And, they pay me to advise them, and they pay me to speak on their behalf, and they pay me to find the answers. And eventually, people like me get promoted to become judges who then decide who gets to walk home with the money and who doesn't, who has to pay costs, all of these things. And the real distinction about mediation is that the power stays with the parties. So the mediator is a facilitator. The mediator may coach them. The mediator may share things, facilitate, the transfer of information between them. But ultimately, if they reach a solution and the shape of that solution is something for the parties to decide, it's something they can own. And I think that is where the transformation ends up happening, because when you're engaged in a process where it's not a zero-sum game, where the winner doesn't take it all, where the loser isn't left with nothing, you have a much better prospect of seeing the best in people rather than the worst in people. Because you'll often hear from people who are embroiled in a legal conflict that it's brought out the worst in both of them. I'm not a family mediator, but often, and I know that's one of the contexts where you see it the most, often litigation in a family context is corrosive and really destructive of children in the family, of whatever remains of that family. And the reason I think that happens is because both parties are scared that the decision is outside their hands, and the decision is in the hands of a judge, and they can't control the outcome. And so they do everything in their power to take everything to win, because it's a zero-sum game. Somebody's going to win, somebody's going to lose. And so they don't behave very well. Whereas in the context of a mediation, if you're able to create a safe enough space for the parties, they're able to regulate some of that anxiety about the outcome. And they realize that the outcome is in their hands, that if they settle within the context of the mediation, they can settle on whatever terms are agreeable to both of them. And so they may be much more willing to compromise. And they're not restricted to legal solutions. They're not restricted to things that a judge has to, a judge can't say, well, you know what, I'm not going to order what I've been asked to order. I'm just going to come up with this completely other setup for you. It just doesn't work like that in litigation. You set out in your claim what you're claiming, and you get, if you win, what you claimed, and you don't get what you claimed if you lose. Whereas in the context of mediation, you often see, for example, in a business context, that they realize there's other synergies. There's actually another business they might, agree to enter together. They might help each other out on the side with something else. So people get very creative about solutions when they have more information about their interests rather than their positions. So if I knew one of your interests was speed, I might be able to do something to help you as the other party on the speed front. So I'll do this and you do something else for me. And before you know it, you've come up with an entirely unique solution that only the two parties, knowing their own interests and priorities, are able to come up with in a context where a judge would never have been able to arrive at the same outcome for them. And so those are the three key aspects of mediation for me, but I'm happy to address other issues and questions later. And then just a quick summary of a comparison between mediation and litigation. Mediation is consensual, so both parties have to agree to mediate, hence the agreement that's signed by everybody, whereas litigation is adversarial. Normally the claimant files a claim and then you're forced to defend. You don't get a say in whether somebody sues you or not. Mediation is relatively inexpensive. Litigation can literally cost in the millions, depending on the size of your legal disputes and the size of the legal teams representing you. Mediation is confidential, which can be very important in certain sensitive contexts. Litigation, with the exception of some very, very limited context, is part of the public record. So everything you say in evidence, what the judge says about you, is all out there in the public record. What I just mentioned at length previously, formulation of mutually agreed solution between conflicting parties versus decisions made by external party, which is a judge in most cases. The timescale is determined by the conflicting parties in mediation, whereas litigation can run literally for years, depending on the size of the dispute. Potentially a downside, it's less regulated. So if the mediator isn't quite as impartial, objective as you might like, it might be difficult to challenge, although most mediators these days are subject, will comply with codes of conduct and would normally provide avenues for complaints, especially if they're regulated by a particular body. And then litigation is obviously subject to formal review. You can appeal an outcome that you don't like in litigation. One of the other potential, you could say, downsides in mediation is that you might not have a solution at the end of the day. From my experience with mediation, you will still have learned something useful at the end of the day, even if you don't walk away with a solution. But on the other hand, litigation will always necessarily lead to resolution because the judge will have a final say about what happens. So that's it from me in terms of my initial talk. Thank you very much for listening, and I'm very happy to answer any questions.
Thank you, Zahra, for that in-depth sort of review of mediation and taking us through the various, well, starting off with conflict and how it evolves and can be resolved through mediation being the area you touched on. In terms of questions that are coming from those that are viewing both on YouTube and over Zoom, you can put the questions in the chat box on Zoom as well as the public chat on YouTube. So as soon as they come in, I will pick those up. But I had a few questions of my own. Zahra, if you could sort of tell us, in your experience, what are the key sort of secrets or success criteria where mediation is likely to succeed? Sort of what do you think individuals need to be at? What sort of mind frame? I'm not suggesting that's one of them, but what leads to a successful mediation, or what may lead to an unsuccessful mediation in your experience?
I think in the context of mediation, although I was sort of taking it away a little bit from the legal principles and the legal concepts, I do think if it is a complex legal dispute and if there are questions about what does the contract mean and all sorts of other legal questions that could arise in the context of a mediation in a legal dispute rather than mediation generally, then I actually think it's important to recognise that the mediator doesn't replace the need for lawyers. And I say that because when you come to a mediation, you need to have some notion of your best case scenario and your worst case scenario in relation to the dispute you're engaged in. And to be able to work that out, you need to have some really good legal advice. Mediators, even when they do have a legal background, are not there to provide legal advice. They're not supposed to provide legal advice, and they won't provide legal advice. So they will test your legal case. So if there's obvious flaws with the legal case that I can see on reading the papers and reading the position statements, I might push back against that gently, so that, because you do end up with things like kind of optimism bias. You've only ever heard your camp, you've only ever believed your camp. Your advisors might have lost the sense of objectivity after a while. And so having a third party say, oh, how do you think that would land with a judge? Or, what are you going to do about this particular problem? You've said to me you can't get hold of the witnesses. How do you think you're going to prove this point? So some testing of the legal case will be done by the mediator. But I think it's massively helpful for people. They really ought to do that before they engage in litigation in the first place, is to ask, what is this claim worth, or what are my prospects of success? And then if you come to the mediation with that understanding, you at least have a vague understanding for your bottom line might be. And if you don't have that information, it might be quite difficult to decide whether you're being made a good offer or whether you're being exploited. Should you accept, shouldn't you accept? Because ultimately the mediator is not going to tell you whether a solution is good enough. It really is the responsibility of the parties to propose the solutions and to decide whether they like those solutions enough to put them in a legally binding document. So I would say an open mindset, some good faith. And the faith doesn't need to be in the other person. The faith can just be in the process. So a leap of faith in the process, an open mind, good preparation in terms of understanding your case. And finally, the slightly technical point, but it's quite vital, and I probably should have covered it in my, key points about the agreement, is authority. So are the people pitching up to the mediation people with authority to sign the agreement? Are they going to bind the company in question? Is there a partner who isn't in the room who actually calls the shots in that case? And that's my job as a mediator ahead of the day, is to make sure we bottomed out these things. To bottom out, do you have proper authority? Are the people who are going to show up prepared and ready to engage in this process? But one of the things I didn't touch on when I was talking about the role of the mediator is that often a mediator is sort of like a coach. And so it really is your job as the mediator to explain these things as early on in the process as possible. So as soon as you're engaged by the parties, you say, okay, here's what I need from you. Here's when I need it by. Here's what you need to be thinking about. Here's what would be helpful. And then that increases the prospects of everyone showing up prepared and ready to get down to business, really.
No, thank you for that. Now, just picking up on that, sort of, if you do get the decision makers there, they've come with the advice, they've taken the leap of faith, but they each take the view that we're too far apart. We're stuck in our positions.
Yeah.
There's millions between us, or whatever the decision in dispute, whatever the item in dispute. Do you still think the bridge can be met with a skillful mediator at hand?
Yeah, and it often is. I mean, mediation has a very high prospect of success. It often is because the positions are very far apart. But if you remember that slide about positions and interests, normally when you dig a little deeper, you realize that actually you might not be as far apart, or you may still be very far apart on the money, but then there is something else that could alleviate a particular concern, which would bring you closer to each other on the money. Now, what we're seeing more of these days is mediations that don't result in a settlement on the day, but mediation agreements will often say the mediation doesn't end until one of the parties has confirmed in writing that the mediation has come to an end, or the mediator has decided that we really can't take this any further. So what you'll often see is you come to the end of a long day, people are tired, they've moved millions, and they come to the last, £20,000, and they're like, no, I'm not budging. And the other one's saying, well, I'm not budging either. And sometimes the wise thing to do is to say, well, let's call it a day, and I'm going to call you to, go away and think about this, and I'll touch base with you tomorrow. And maybe, there's lots of creative ways. I think it's kind of all about figuring out why people are locking horns, what it is that's getting in the way of resolution. And sometimes the key to that is to actually remove the lawyers. So sometimes you'll propose a session in which the key decision makers sit on their own in a room without their lawyers, because their lawyers might be the people sort of posturing, because sometimes people do that. They're so used to taking their client's position that they start becoming unhelpful in the context of mediation. So you think, okay, well, I think I need to lose these guys at least for an hour or half an hour or 15 minutes, or however long the decision makers want to talk for. And so you try different tools. But I think the key thing is not to move into bargaining too quickly. Because if you move into bargaining too quickly, you get entrenched in your positions. So what a mediator will normally do is spend the first part of the day just exploring what people need, what have they not told each other yet? What more do they know? What don't they know? And that then gives you the material you can work with to try to bring them together. But ultimately, I'm not going to be owning the solution. They have to own the solution. So they have to want it, and they have to be willing to make whatever compromises they need to make to get there.
I think you touched on a key point there. You mentioned it during your talk that litigators, we like control. We like to tell people what to do. Usually clients tell us, this is my problem. We say, yes, I have the solution. This is exactly what you should do. And when they don't follow it for whatever reason, we tend to get annoyed. We say, well, I told you so.
Yeah.
Now, litigators, and obviously we're closely linked with the mediation process in a commercial setting anyway, because we get taken to them, and we in fact encouraged it at instances as well. You mentioned obviously that these sessions, that sometimes you need a session where the litigators are kept out, but also in terms of that creative solution session, where I think the skill of the mediator can come to shine.
Yeah.
How much do you think, in your experience, you found that creative solutions are derived from business people to sitting together, which the litigators would never been able to, because we're stuck in our legal positions.
Yeah.
And we've never sort of taken that commercial broad view of two businesses.
Yeah.
That may have synergies that were never explored before, because that's not what we do.
Yeah. So I mean, you can have the creative solutions emerging from the business people sitting together. Sometimes you can have them emerging slowly in private meetings, and so the litigator will be there with their client, but the mediator speaking to the client. They're not the lawyer will have some input, but the mediator is trying to get a better understanding of exactly what do you need in this context. What is missing here? What else is happening? And then you begin to think, okay, so would this work and would that work? And you're bouncing ideas off them as well. They said they don't have money to pay you now. You say you need the money now. What do you need that money for? If they told me what they need the money for, then we might get creative about, well, actually, is there another way to meet that need so that, they can then pay you when they can afford to? Because if you sue them and they become insolvent, you both lose and you get nothing. So can they pay you in kind, for example? And that's, again, another example of something that a judge can't order, right? But if you've got a company that is on the verge of insolvency, you can sue them, push them into insolvency, and then you get nothing. And they've lost their business and everybody loses. But they may be able to pay you in kind. They may be able to pay you in services. So it's that, exploring what they've got to offer, what you need, and seeing if there's a way we can match that so that you both walk away with something that is constructive and useful.
I totally agree that it's quite enlightening to see what other creative solutions mediation can uncover. Another sort of example I'd add is property claims. The court's hands are quite tied in a restricted one or two property claims, but on a sort of property partnership with multiple properties, you could do a swap, which exactly. A judge legally can never order unless
and that sometimes happens in family disputes. Okay, so you move out of the family home, but then you get this bit, and I get that, and then people can kind of more collaborative. Once you've worked out what each party needs, really needs, you can then be much more flexible in how you meet those needs.
I think you mentioned earlier, and you've emphasized it as well, it's the ownership, isn't it? The solution has come from both ends, and everyone's owned up to it. A thing that I often hear is a good judgment is where both parties are unhappy. In mediation, usually, if a solution's derived, both should be reasonably happy because they had an input in reaching the solution. In terms of the benefits of mediation as compared to the various options that you have to ADR and the emergence of FDR, financial dispute resolution, with court mandating directions. What is your view, and why do you think, if you do think, mediation is more beneficial as compared to the other options that are emerging?
Well, I mean, I think every dispute resolution method has its ups and downs, right? So nothing is perfect, and no dispute resolution method meets everyone's needs in every way. But I've seen quite creative combinations sometimes of mediation as well as other things. And sometimes one of the things that's proposed in a mediation is, for example, expert determination of one of the issues. So you can, in the context of the mediation, if you're stuck on expert issues where actually you just don't have the information in the room to decide the issue, to settle the issue, because one side is saying, well, we think our engineer said this building isn't safe, and the other side is saying, well, our engineer said it was safe. Neither party can say, all right, fine, then we'll just go along with it, because they both have really serious obligations to ensure that the building is safe, that all sorts of legal consequences can follow from not being genuinely convinced that all requirements met. And so you could then settle the money disputes in the mediation, but then agree between you that the safety issue would be determined through an expert adjudicator. So that's someone essentially playing the role of a judge, but they're an expert, they're not a lawyer. So they may be a valuation expert or structural engineer or whatever it is that you need for your context. And you both agree in your mediation agreement, in your settlement agreement, that you agree to be bound by their determination. And, if the mediator is thinking far ahead, it's making sure that they've agreed a robust enough process for appointing the expert valuer, because you don't want the whole thing to fall apart at that point. So it's, you have to anticipate in what ways could this go wrong. And so, you've got process for appointments, you've got both sides have agreed to be bound. And there you find yourself combining two methods of dispute resolution. There's now a growing number of mediation and arbitration clauses. And so you go to mediation first, but because the parties are so keen on resolution that if they can't resolve their conflict, it then automatically goes to an arbitration. And the arbitration has the advantage of forcing resolution. And so, if people are too entrenched and they can't move forward sufficiently, but they actually need a solution, they might agree ahead of time to do a combination of both. So I don't think we necessarily need to pitch them against each other. I've spoken at quite some length about what I see the benefits of mediation being. And I think out of the different methods, it's the one with the highest prospect of salvaging the relationship, or at least not souring it too much. Mediators often say it puts people above the problems. It's seeing people rather than problems.
I think the last point, I would echo that it salvages the relationship, as opposed to, as you mentioned, it's not a zero-sum game, winner, loser. We have a handful of questions that have come in. Right, so I'm sure you can see these as well. I think this is a good one. Does mediation mean that I'm lowering down my expectations and giving up my rights? Otherwise, in the most ideal scenario, I would get what I want, I suppose.
Yeah, so I think that's what I was saying about working out, doing some thinking ahead of the mediation, but also the mediator's job is to help you unpack what's the best case scenario here, right? If you were vindicated and you won, what do you get out of this process? And if you were not vindicated and you lost, what are you risking? Or what are the prospects of what you're risking? And does you winning get you everything you want? And because of the dichotomy I've drawn attention to between positions and interests, it's often the case that even winning doesn't get you what you want. And I'll give you some really kind of basic examples of why not. There may be much more interesting ones, where there's kind of hidden health issues or hidden, as I was saying, sometimes there's, the dispute is so acrimonious in the business partnership that it's putting the families at risk. The partners have said, as in the marital partners have said, I've had enough of this, I can't cope with this anymore. You've got a day to sort this out or I'm out. So sometimes you've got that on the side, which the other party isn't aware of. But even if we put the slightly dramatic examples aside, litigation takes time and it costs money that you have to pay until you win, right? So it might be that after the judgment, because you've won, you get an order for your costs. Normally, an order for costs would only cover at most about 2/3 of your costs. So there's sunk costs that you'll never recover. But even if you didn't not recover the sunk costs, your money for the entire period of time up until the judgment, rather than being invested or spent on holidays or spent on education or spent on your children, is being funneled into making lawyers, much richer than they need to be at times. And, and not just your money, but your time, because litigation is very time intensive. The lawyers can do a lot for you, but at the end of the day, they need you to engage. They need your evidence, they need documents from you. And so you're constantly going to have to give up your time to engage in that process. And what people often don't address is the emotional cost of being at war with someone for potentially a number of years is really significant. And so if you weigh those things in the balance, even when you get that declaration or order at the end of the day that says, yes, you're right, you win, are you actually getting what you need? And how much have you paid? How much has it cost you? And I don't mean just in monetary terms, although I include monetary terms, but how much has it cost you to get that win at the end of the day? And was it worth it? It's not my job as a mediator to tell you that it's not worth it. It's my job to ask you those questions. And it might be that sitting in the room, you think, actually, if I can sign an agreement today that ends this today, who cares what a judge is going to say in 3 years' time? I don't want to know. I can control how much I can get today. And if I can get enough, if it feels like it's enough for me, and then I get to draw a line under this and walk away and never look back, then maybe that's a much bigger win than winning in court.
I think sometimes I've heard judgments being described as a very expensive piece of paper.
Yeah.
To show that you've been vindicated, whatever you've been asking for. And
then you'll probably find that it doesn't feel quite as exhilarating as you think to get that vindication, because you've paid so much to get there. But also, as I was saying earlier, does the vindication get you what you need when you think, even in practical terms, about, the liquidity of the other party? Are they going to be insolvent by the time you get to court? Are they going to be good for the money when you get the judgment? Because the judgment isn't money. The judgment is just a declaration that you're entitled to the money. You then have to go engage in a whole other enforcement process where you sue for the money. And, then you're back at square one, sort of chasing for your money again.
Indeed. See, this is a very interesting question here from Alia Mukhi, sort of saying, what are the risks of mediation as opposed to, I suppose, and this is sort of in the context of a family dispute, but if we just sort of apply the general mediation principles, are there any risks to mediation?
Well, I don't know. It's a good question. Part of it is what I was saying earlier about, a safe enough space. Can you create a safe enough space? And I can imagine that in some context, there would be an emotional risk around engagement in a mediation. There's an emotional risk because things might be so acrimonious that you feel just being in the same room as the other person puts you at an emotional risk. But I think if you raise those issues early enough, they can be mitigated. And the mediation, for example, is so flexible and so fluid that it can take place entirely remotely. So you can stay in your home with your Zoom on, especially now post-COVID days. We're all used to technology. So you can stay in the safety of your home. The other person stays in their home. And you may say to the mediator, I don't ever want a plenary session. I don't want to be in the same, even online room as this other person. I just simply can't engage with them. And that would be fine. And so you're mitigating the emotional risk there. I think other risks, as I said, mediation agreement seeks to minimize those. So, given it's a legally binding document on everybody, it seeks to minimize the extent to which the information shared could be exploited in another context. It seeks to minimize, kind of leaks in confidentiality between the mediator, if you've disclosed something to the mediator, it's a really serious breach of the mediator's code of conduct to go and tell the other side without your permission. So I think, everything in life probably does carry some risk. I can't currently envisage what sort of significant risks one would run by attempting a mediation. But I could be wrong, Allahu Alam.
The only thing I'd sort of add from the litigation experience, sometimes the minor risks to mediation perhaps can be as a cost building exercise.
Yeah. So there is some
to
cost.
Settle is simply add everyone's costs, and we're going to come out at the other end and continue fighting.
Yeah.
Or to determine what issues are vulnerabilities on your opponent's side, to extract those again with no genuine attempt to settle it. But those mediations don't tend to last very long anyway, because mediators would tell if there's a genuine attempt or not.
But you're very limited with what you can do with what you think you've extracted, right? So you can't put it in a skeleton argument, you can't make it in a submission in court. So, people often speculate about the other side's vulnerabilities anyway, and it still doesn't help them, because ultimately it's up to the judge to decide what happens if you go down the litigation route. And I think, that's what the importance of the mediation agreement is, that you absolutely have to make sure that people can't then exploit this information in any other context. And you can sue on it, you can seek an injunction if somebody tries to breach a mediation agreement, to prevent them from doing so. And the courts would uphold that, because there's a massive public interest in preserving mediation as a form of dispute resolution. Indeed.
We've had another question just come in now. Can one party unilaterally terminate a mediation and proceed with litigation?
Yes.
Yeah.
Yeah, people can get up and walk away within half an hour, and there's nothing you can do to make them stay. You normally ask them to sit down just so you can explain a few things, and by then they might have calmed down. Part of the coaching that a mediator will do is try to anticipate when one thing said by one party. Right? So part of my job is to try to prevent a situation in which people are so explosive and so uncontrolled in what they say that somebody walks out. And so, you don't bring people into a plenary unless they're being very constructive and they've already said to you, yes, I'm here in good faith and what I want to say to the others. You might coach them about how they present their case in the plenary. So, put it in constructive terms, talk about how you want to move forward. And then, you sort of police that process to a certain extent. So if someone's jumping in, you're saying, I'm going to need you to wait, please, until this party's finished presenting, and then you're going to get your turn. And I'll ask the other party to just listen. I understand you're not going to agree with each other. I understand we're not going to meet each other halfway within the first, 30 minutes or so. And then, part of your job then becomes when you get to the bargaining phase of the mediation, is to try to encourage the parties not to make offensive offers. And so some coaching around you. How do you think they're going to receive this offer? So if they're suing you for 10 million, well, okay, I'm going to start with 100. Really? Whereas, if you're just doing it mechanically, you go, okay, I'll take your offer over to the other side. And the other side will say, you're completely wasting our time. This is a joke. They'll pack up their things and leave. So part of the mediator's role, you can't always control it and you don't always control it. But it's to try to anticipate where something said by someone might anger the other side. And sometimes you say to them, are you sure you want me to take this across? Because, they're not going to receive it well. And you're told, yes, I do, this is my offer and I do want you to take it across. And you go to the other room, the other side receive it very badly. And then you just try to keep them in the room long enough for them to calm down. and kind of sit down and say, okay, well, what's next after they've calmed down? But the whole point of it being consensual and being non-binding until there's an agreement is that people can walk out and they can withdraw, and they're free to do so.
No, indeed. Another good question: who polices the mediation agreement? So you've done all the hard work,
it's a legally binding contract.
So it's contractual agreement, which again, unfortunately, would have to go back to the court process.
Yes, but what you have achieved. So you might think, well, hang on, that's entirely pointless. It's not, because what you had at the start of the dispute is, are you even entitled to what you're asking for? And you need to go through 2 or 3 years of legal disputes to find out. You then have a really clear, simple agreement that says, I'm entitled to X. And the other side has agreed that, and they've signed it. And so you enforce it in the same way that you'd be enforcing a judgment if you had obtained a judgment. So yes, there is another process, but you've achieved something by skipping through to that process immediately. And you might need another mediation. You might have to actually go back to a mediation because it turns out your agreement was unworkable and you can't just unilaterally breach it. So you need to renegotiate it. And you might find that negotiating it with the help of a mediator is slightly more productive than trying to negotiate it directly. But solicitors, I mean, I'm sure you know, solicitors and barristers are often engaged in negotiations. You know, we're always making things happen for our clients without the help of mediators. It's just that, you know, when things get protracted or people get stuck, then you think, well, I need a third party to come in and facilitate the bringing together of these two sides.
Indeed, and I do echo that. In terms of obviously the mediation agreement, as well as you quite rightly put that, it's a legally binding contract and will be enforced by the courts. Just a final question to end on then. How do you distinguish between good mediators and bad mediators, and is there such a thing?
I'm not sure I can answer that question. I mean, I guess, you know, what are the attributes of a good mediator? Somebody who is a good listener, that's absolutely key, because if a mediator isn't able to draw out of people what their underlying interests are, then they're not going to be very effective in creating value for that bargaining phase that you then get onto later. I'd want someone who understands very well their obligations to treat everything said to them confidentially, and is therefore able to create that sense of safety. And I'd want someone who, while being empathetic and kind and understanding, is also authoritative about their process. So not authoritative about outcomes, but someone who is able to lead on the process and, you know, doesn't just sit back and say, well, it's up to the parties, because then they're not bringing any value to the table. But if they're able to lead on the process, you know, while seeking the consent of the parties, but able to say, actually, you know, I think it really would be useful for you to try this right now, or to take a break, you know, and then, you know, experience. I mean, I wouldn't want to go on about experience too much because I'm fairly junior, but, you know, I'm sure experience plays a huge role in whether someone is a good mediator or not, because they've seen different situations, they've tried and tested different ways of dealing with different situations, and they've come to some insights that you can only really achieve, I think, through practice.
Indeed. If I hand over back to you, Zahra, then to finish off today's session.
Yeah, so all I was going to say at the end, and I think, just going to share my screen again. All I was going to say at the end is that the viewers and participants and listeners may or may not be already aware that CoEJ has set up a mediation service. There are two aspects of the mediation service, and please do jump in and correct me if I'm wrong, but there is a community/family mediation service in which a number of mediators for a number of years now have been trained by the College of Mediators, or regulated by the College of Mediators, but trained to their standards to offer a mediation service in those contexts. that is entirely free and entirely confidential and seeks to help people even within an ongoing marriage. So it's not solely focused on, you know, divorce settings or where marriages are broken down. It's in the context of anyone feeling they need a facilitator to help them resolve a conflict or a dispute. And if you remember, one of the very first slides I went to, and one of my key messages was that we shouldn't fear conflict. And it's much better to confront a conflict head on, to try to improve your skills yourself in dealing with it, or to seek external help in facilitating resolution for it, than to let it fester or to walk away or to ignore your own needs and interests. And what we are launching today is the commercial aspect of CoEJ Mediation Service, in which I think eventually, as it grows, we'll hope to have a panel of commercial mediators. At the moment, you just get me. And while we volunteer our time for free to run the service, there is actually a small cost for the commercial mediation service. So very reasonable rates, and any money raised through those rates is then put back into training community mediators and family mediators to grow this offering for the community and, inshallah, benefit everyone. So I've put the link to the website there. You can have a look, coej.org/mediation, and learn more about the service. And there's a contact number and contact email address if anyone would find that helpful.
Thank you for your time today, Zahra, and taking us through mediation and answering all the questions that come in. We weren't able to answer all the questions, but hopefully from the Secretariat, whatever information is required, we may be able to disseminate it if the questions were emailed into the Secretariat. But
I'm very happy to do follow-up sessions if people are interested. You know, I think just getting the message out there about what mediation is and what it can do is a really important one, regardless of where you end up going for your mediation service. It's just very important for people in the community to understand that help is out there when there is a conflict, even if it has a legal angle to it. They don't have to be embroiled. You know, they don't have to either give up their rights and walk away because, you know, the partnership might be a family partnership or something like that. You know, even businesses within our community can be between siblings or whatever, and then people feel like, yes, I'm being wronged here, but I don't want to take this to court because I don't want to destroy my family. Well, there is another alternative in which you can still have your rights vindicated, potentially, possibly, if the two sides agree, without having to adjudicate or litigate.
Indeed, and mediation has grown and will continue to grow as quite a strong dispute resolution avenue. But yeah, thank you everyone for participating, and thank you once again, Zahra, for your time this evening.
Good night. Thank you.
Thank you.
Bye-bye.